All right, in counts 1 and 3, you're charged with the offense of possession with intent to deliver a controlled substance, penalty group 1, 4 grams to 200 grams. That's a first-degree felony. Range of punishment is anywhere from 5 to 99 years or life in prison and up to a $10,000 fine.
Welcome to the American Files.
All right, court is calling 2020 CR 7235, State of Texas versus Moses Albert Martinez. Can I have parties announced for the record for the state?
Jason, get right hand, Your Honor.
Defense?
Tilden Schaefer.
Are you Moses Martinez?
Yes, ma'am.
All right, counsel, have you received all the discovery? Did you review it with your client?
Haven't I did, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Martinez, I'm showing you what's entitled application for community supervision. Did you review that with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
I'm showing you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment? State, are you proceeding on the indictment as presented?
No, Your Honor, we're proceeding on count 1 and 3 alone, leaving count 2, 4, 5, 6, and also the enhancement paragraphs.
Any objection?
No, Your Honor.
And count 2, you all have that listed as a first degree or second degree?
Going with count 1 and 3. And those,
Oh, count 3. Okay.
what if we skip, it's with intent.
They're
and
both
they're
first
just
degree
first
is,
degrees.
Oh, yes. Okay. I thought you all were, my mistake. I thought you were going on count 2. That's why I was like,
I purposely-
second degree?
Yeah.
What? Okay. All right. If you all can do one thing for me then, so it can be clear. If for this part, you all will add the count 3.
Okay.
The offense for the count 3.
But it's the
same offense.
No, let me see.
Yeah.
Put times 2.
drugs, Your Honor.
No, no.
The same offense, just different drugs. They're both
Yeah,
scheduled
one's
1.
heroin, one's meth.
No, count 3. Oh, I'm looking at the wrong, this is a different indictment that's in the file. No wonder that's throwing me off.
Oh, yeah, this
Yeah, that's completely different. Okay.
Oh, there it is, the missing indictment.
Yeah, I was just like,
Wow.
yes, it was in this file. So,
No objection to getting rid of that indictment in my client's file, Judge.
all right. No wonder, because I was like, this isn't reading right.
Thank you.
Yeah, it was in this
I
file.
almost passed out, Judge.
Okay.
Wow.
Because I was like, this is a burglary. What is this?
Yeah.
Okay. All right, now I see. So this is the proper indictment. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
All right, and do counsel, you waive the reading of the indictment?
Still.
All right, and state you're going on counts 1 and counts 3?
Yes, Your Honor, 1 and 3.
And you're waiving 2, 4, 5, 6, and the enhancement, correct?
That is correct, Your Honor.
Any objection?
No.
Going to show you what's entitled court admonishments. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
All right, in counts 1 and 3, you're charged with the offense of possession with intent to deliver a controlled substance, penalty group 1, 4 grams to 200 grams. That's a first degree felony. Range of punishment is anywhere from 5 to 99 years or life in prison and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand by entering this agreement, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case?
Yes.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
You believe he has a rational as well as a factual understanding of the charges against him?
I do, and he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes.
Mr. Martinez, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am, I did.
According to the plea, the state is proceeding on count 1 and 3. Punishment is to be assessed at a cap of 10 years in the prison. There's a $2,500 fine. State opposes your application for community supervision. They will take in consideration NITMAC number 751468 with the corresponding JN number 2165970. And there's to be restitution for drug testing. Did you understand that to be the plea?
Yes, ma'am, I did.
Defense?
That's fine.
State?
It is
Showing you the waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am, I did.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Then how do you plead to count 1,
Guilty.
count 2?
Or 3. Count
I'm sorry, 3.
Guilty.
Okay. So to count 1 and count 3, you enter a plea of guilty, correct?
Yes, ma'am.
State any evidence to support the plea?
yes.
Any objection?
No, Your Honor.
State, you may continue to confer. Showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney?
Yes, ma'am, I did.
Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, court will find there's sufficient evidence to find you guilty, and the court will find you guilty of count 1 and count 3. All right, what date are we bringing this back? May 8th, you know that's Wednesday.
I think it is a Wednesday.
Are you, May 7th?
Yes.
All right, we'll come back on May 7th. I'm going to set this for a PSI and a TAP evaluation. And what will end up happening is I'll base my decision on your application based upon the PSI and the TAP evaluation and any other information that's submitted.
And then Judge, when he was arrested on the new case that's being taken into consideration, his plea deal, he was taken into custody on the February 15th, and he's been in custody ever since. I just need it. I think we need a bond set, but more importantly, I want to make sure, given the nature of the plea agreement, that we're, for the record, noting he's been in custody on with this
Oh,
warrant.
depending on what happens, if I decide to sentence him to prison time, he'll receive credit for that time.
Wanted that.
Yes.
But-
And I'm not saying that I am going to send you to prison, but if that were to happen, you will receive credit for that time because you've been in custody. And if there's any bond that needs to be made on the other cases,
It's this case. It's the
this
only one.
case,
He had a failure to appear judge, and so there's an outstanding warrant. For some reason, the jail has not acted on the warrant, which is why he got arrested in the first.
all right. Well, since he failed to appear, you all will have to set a hearing and then I'll make a decision on bond.
Yes, sir.
All right. Is there anything else?
No.
All right. Thank you.
Thank you, Judge.
In this courtroom hearing, the case of State of Texas versus Moses Albert Martinez is called before the judge. The defendant, Moses Albert Martinez, appears in court with his defense attorney while the prosecutor represents the state of Texas. At the beginning of the hearing, the judge confirms that Martinez has received and reviewed all the discovery evidence with his attorney. The court also verifies that he reviewed and signed important legal documents, including the application for community supervision and the indictment. The prosecutor informs the court that the state will proceed only on count 1 and count 3 of the indictment, while the remaining counts are waived. These charges involve possession with intent to deliver a controlled substance in penalty group 1 between 4 and 200 grams, which is considered a first-degree felony under Texas law. The judge carefully explains the possible punishment range to Martinez. For a first-degree felony, the sentence could range from 5 years to 99 years, or life in prison, along with a fine of up to $10,000. Martinez confirms that he understands the seriousness of the charges and the potential penalties. The court also explains his constitutional rights, including the right to a jury trial, the right to confront witnesses, and the right to remain silent. Martinez acknowledges that by entering a plea agreement, he is voluntarily giving up these rights. According to the plea agreement presented in court, Martinez agrees to plead guilty to count 1 and count 3, with the punishment capped at 10 years in prison and a fine of $2,500. The state notes that it opposes community supervision, but the court will consider further information before making a final sentencing decision. Martinez confirms that no one has threatened or forced him to accept the plea and that he is satisfied with the representation provided by his attorney. After reviewing the written stipulations and evidence submitted by the state, the judge determines that there is sufficient evidence to support the guilty plea. The court officially finds Moses Albert Martinez guilty on count 1 and count 3. However, sentencing is not decided during this hearing. Instead, the judge orders a pre-sentence investigation, PSI, and a substance abuse evaluation. These reports will help the court determine the appropriate punishment. The case is scheduled to return to court on May 7th, where the judge will review the reports and decide the final sentence. The defense also notes that Martinez has been in custody since February 15th, and the judge confirms that if a prison sentence is imposed, he will receive credit for the time already served. The hearing concludes with the court scheduling the next appearance, where the final outcome of the case will be determined.